your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Chinchilla Magistrates Court. It's about a 3.5 hour drive west of Brisbane. Used to be 4, but now that we've got the Toowoomba bypass, it's closer to 3.5. Client was charged with mid-range drink driving, reading at .130. Worst case for that's a 12-month disqualification. Mandatory minimum's 3, but the mid-range bracket kicks in at .100. High range is .150, so with a reading of .130, you're closer to high range than you are low range, which is up to .099. So yeah, he's looking at 3 to 12 months with a reading of .130. It was his first offence, so there was no previous. He hadn't lost his licence in the last 3 years, and he was on his had an open Queensland licence, so he ticked all the eligibility boxes to apply for a work licence, but he was able to manage for some period without driving for work, so he elected not to apply for a work licence. And he works in I'm not going to say what he does, but he works in a particular profession that requires ongoing membership of a professional body. So he wasn't a lawyer, but for example, lawyers need to be members of the Queensland Law Society and maintain ongoing membership, and if things like this happen, they need to be disclosed upon renewal of that membership, and it can cause difficulties. So there's a number of professions, I'm not going to say what he does, but you know, nursing, doctor, school teacher, that kind of thing. There's these ongoing memberships that require ongoing disclosure of incidents such as this. And what I'm getting at is, given what he does and given that ongoing disclosure, he was concerned about the recording of a conviction. So drink driving is not a criminal matter. It's, no one ever gets a criminal conviction for a drink driving charge, but unless they're also charged with dangerous driving, but my client wasn't. But you ordinarily get a recorded traffic conviction, which goes on your traffic history. So people will either have a traffic history or a criminal history, or both, or neither. And as I said, drink driving goes on your traffic history, and it ordinarily comes with a recorded traffic conviction, not a recorded criminal conviction. So the impact of recorded traffic convictions nowhere near as severe as the impact of a recorded criminal conviction. So as you can imagine, if someone's got a recorded criminal conviction, they're effectively criminal, and it can cause all kind of difficulties with seeking work and, you know, child access and all the likes. But whereas a traffic conviction really isn't of any tangible impact unless you've got unique circumstances, such as being a part of the type of professional body that I've described, with those ongoing memberships and ongoing disclosures. So as I said, the short version of what I'm trying to get at is he wanted no conviction recorded. So my job was one of twofold: getting the disqualification down as low as possible and trying to push for no conviction recorded. Basically, got my client to do a number of things. There's an online form we get all of our clients to fill out that presses you as the client to tell us your life story. So who you are, background, you know, upbringing, education, employment, family situation, you know, what happened on the day in question. Sometimes there's mental health issues, or there's a death in the family. You know, everyone's life story is unique, and we need to know it. And the online form that we've created, you know, it specifically targets you to give us answers to questions that, you know, it's not invasive or particularly nosy, but I mean, the magistrate needs to be put in your shoes, and in order for us to be able to do that, we need to get information from you that allows us to put them in your shoes. So, you know, if you've had a great life, we need to put the magistrate in your shoes of this great life you've had. If you've had a traumatic life, or, you know, there's issues at play that cause you to find yourself in the situation that you're in, the magistrate needs to know. And don't get me wrong, we don't just stand there and tell the world and the whole courtroom and the media for their present your business. We're very good at using what the military called veiled speech. So I'm ex-army, and veiled speech, basically, you know, if you'd imagine if you're at war and you're on the radio, you can't just blab and say whatever you want, because obviously the enemy's going to hear it. So the army use what's called veiled speech. So no one other than you and the person you're talking to knows what you're on about, because you're using language that keeps things vague to people who don't need to know what you're saying. And I use that tactic a lot in the courtroom. Myself and my colleague Clancy, we've got a knack for speaking in a manner that only the magistrate and the prosecutor and the client know what we're on about, and particularly when we're trying to go for no conviction recorded. I mean, if you get up and say, my client should have no conviction recorded, blah, 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 obviously the next guy that gets on after you is just going to repeat everything you said. And if you do that to like if you sabotage a magistrate by, you know, triggering 30 people demanding no conviction recorded, next time you go to court, what's the magistrate going to do? They're not going to do it for you. So anyway, what I'm getting at is veiled speech to persuade the magistrate to get on board with our submission of no conviction recorded, without putting them in a situation where they've got to deal with a whole courtroom of people saying, I want the same thing you just gave to that guy. Anyway, got it. That online form, we got him to fill that out. That allowed us to prepare our submissions. Got him to do the reformatory course we get everyone to do. Got him to get character references we give to all of our clients that guide the referees as to, you know, how the reference needs to be structured. I mean, we don't tell them what to say, but we just emphasise, you know, who it's going to be addressed to whom it may concern isn't going to watch, you know, what key points need to be covered in the reference. Because, I mean, if you hand up a reference that doesn't comply with the requirements, the magistrate will either ignore it or just push it to the side, and you know, at best it'll get ignored, at worst it'll just agitate the magistrate for wasting their time. But anyway, got him to get those references. I prepared my submissions a couple of days ago. I drove up yesterday, stayed at Chinchilla last night, met the client at court this morning, ran through my submissions, the procedure, what he can expect to happen in the courtroom, etc. I went in, basically, I was being a little bit cheeky. I was trying to push for the mandatory minimum 3 months, which with a reading of 0.130 is a bit cheeky. I pushed it as hard as I could, and obviously I pushed for no conviction recorded as well. The magistrate, like, basically told myself and my client that, you know, to expect a best case scenario of 7 months. Well, ordinarily in this jurisdiction, for that reading, 7 months is the best possible outcome. Obviously, I had to sort of speak forcefully on my feet in response to that and try to win the magistrate over. And I was ultimately able to win them over, I guess, 90% of the way. So what I'm getting at is I was able to persuade the magistrate to give a 4-month disqualification. So 4 months for a reading of 0.130, whilst the too proud for my own good part of me would have liked 3 months. I'm happy with 4 months for a reading of 0.130. As I said, the worst case is 12. The magistrate indicated that ordinarily they'd give 7. So 4 months is a good outcome. Again, I would have liked 3. I'm not going to pretend I wouldn't have, but, you know, if I can't get what I want, what's a month between friends? And further to that, I was also able to persuade the magistrate not to record a conviction. So 4 month disqualification, modest fine, excuse me, no conviction recorded. Client's relieved, very happy, grateful that when they need to disclose this to the powers that be in due course, the traffic history will have in big capital letters no conviction recorded. So it still goes on your traffic history, but the words no conviction recorded appear in capital letters below the entry. Again, 4 months, modest fine, no conviction recorded. I'm Andrew Wiseman at Chinchilla Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road. Does your license need saving?